Picture this scenario for a second.
Okay.
You are perfectly happy in your job. It's a secure, long-term position. You know the ropes. You are well respected.
Right, the dream.
Exactly. But then a corporate headhunter comes along, and they aggressively pitch you on a massive new project at a different company.
Oh, boy.
Yeah. They promise long-term security, robust funding, and a highly lucrative career path. I mean, it just sounds incredible.
So you jump.
You take the bait, you resign from your safe job, you sell your house, you uproot your entire family, and you move across the country.
Wow.
And then just a few months later, you find out the funding for that quote-unquote massive project fell through.
Ouch.
The company hands you a cardboard box for your desk, and, well, you are fired.
I mean, it is just the ultimate corporate nightmare, right?
Totally.
You are left stranded in a new city, completely unemployed, with absolutely none of the security you were promised.
It is devastating. But here's the thing. Canadian courts do not just let companies walk away from those broken pre-employment promises.
Yeah, they really don't.
And we're pulling back the curtain on this today, using an incredible legal roadmap from Tony Wong at HTW Law Professional Corporation.
Yeah, it's a great piece of work.
It really is. It's titled Wrongful Dismissal and Inducement to Relocate, the Ultimate Guide.
A very fitting title.
Our mission for this deep dive is to unpack the legal minefield of executive recruitment. We're going to explore how courts use multi-pronged legal tools to turn these corporate bait and switches into just, well, catastrophic financial liabilities.
It gets intense.
It does. Okay, let's unpack this.
So, to really grasp how severe the penalties for corporate poaching gone wrong can be, we first have to understand the baseline.
Right, how things normally work.
Exactly. We need to look at how a standard firing works in Canada and why that normal framework just completely and utterly fails an employee who has been poached.
Because usually people just think about severance pay as a really simple calculation.
Yeah, they do.
Like you get let go, they owe you a few weeks of pay, and, that is that.
Right, but in Canadian common law, the term wrongful dismissal actually gets heavily misunderstood.
How so?
Well, people assume it means the company fired you for an illegal reason or that they lacked a valid business justification.
Like they were just being vindictive or something.
Yeah, exactly. But a company can let you go because of a simple corporate restructuring or even just a genuine downturn in revenue.
Right, that happens all the time.
Wrongful dismissal simply means the employer breached your employment contract by terminating the relationship without providing the legally required notice or, pay in lieu of that notice.
Okay, I see.
And crucially, they did it without proving just cause-like severe misconduct.
So it's not necessarily about the actual reason they fired you?
Not at all.
The wrongfulness comes from how they handled the exit, specifically the financial cushion they are supposed to provide.
You hit the nail on the head. The law implies that unless your contract has an incredibly well-drafted, explicit termination clause restricting you to statutory minimum...
Which most people don't read anyway.
Right, exactly. Unless you have that, you have an inherent right to what is called reasonable notice.
Reasonable notice, okay.
The entire philosophy of reasonable notice is to keep you financially whole while you transition to a new job.
So it covers your salary while you're looking?
Salary, yes, but also your bonuses, commissions, and your benefits for that entire transition period.
Oh, wow, so it's the whole package.
It has to be. But the calculation for that transition period isn't just some fixed mathematical formula.
Right, it's not a rigid, 2 weeks per year of service across the board.
No, courts look at the complete picture of the employee's situation using a holistic framework. Historically, this stems from a famous precedent known as the Bartle factors.
The Bartle factors, what are those?
Rather than a rigid formula, judges weigh several personal and professional elements. They look heavily at the length of your service.
Okay, that makes sense.
Naturally, a 20-year veteran gets a much longer runway than, say, a second-year junior.
Right, obviously.
They also look closely at age.
Oh, really?
Yeah, because there is an inherent market bias against late career talent finding equivalent work.
That's sadly very true.
So employees over the age of 50 frequently receive an extended notice award, often averaging an extra 3 months just based purely on their age.
Which, that makes perfect practical sense.
It does.
It is objectively harder to pivot your entire career and find a matched salary at 55 than it is at 25.
Exactly. The courts also evaluate the character of your employment.
Meaning what exactly?
If you hold a highly specialized or very senior executive role, you command a longer notice period.
because there are fewer jobs like that out there.
Exactly. There is simply a massive scarcity of equivalent jobs for you to apply to. And similarly, they look at the general availability of similar employment in your specific industry.
Okay, so if the job market for your skill set is just incredibly narrow, the court stretches your notice period to reflect that reality.
You got it. And when you combine all these factors, courts generally impose a soft cap of about 24 months of notice, reserved for older, highly tenured executives.
Okay, so standard severance is kind of like a clean breakup.
Right.
You get your stuff back, and the amount of time it takes to financially untangle your lives is based on how long you dated. You know, the tenure, the age, the specialization.
That's a good way to look at it.
But wait, I have to push back here.
Go for it.
What happens if an employee had a really secure 15-year career at one company, they get aggressively poached by a headhunter, and then they get fired by their new employer after just 6 months?
Yeah, that's the problem.
Because we just look at those standard Bartle factors, their length of service at the new job is practically nothing.
Right. 6 months is a blip.
The math would yield a pathetic, tiny severance package. I mean, how is that fair to you, the listener, if you took a massive risk to leave a secure 15-year career?
The short answer is, it isn't fair.
Yeah.
The standard factors completely fail to address the destruction of the employee's prior security.
They just ignore it entirely.
Basically. But when an employer actively hunts down a secure employee, the courts realize standard math is just inadequate.
Okay, good. So what do they do?
To rectify this glaring unfairness, the Supreme Court of Canada stepped in and entrenched a powerful legal concept called the doctrine of inducement.
The doctrine of inducement.
Yeah.
So the courts actually recognize that being lured away changes the fundamental nature of the relationship.
Dramatically. The Supreme Court established that when an employer aggressively lures you away from secure employment, the courts will artificially stretch your reasonable notice, period.
Cool. Just to make up for it.
Exactly. It's a mechanism to compensate you for relying on their grand promises and, for your dashed expectations of long-term security.
They are penalizing the new employer for enticing you to abandon a safe harbor.
That's exactly it.
But, I mean, every job offer has a little bit of salesmanship, right?
Sure, of course.
A recruiter's job is to make the company look great. So how do courts separate standard corporate cheerleading from legal inducement?
Well, not every job offer qualifies as actionable inducement. Courts demand proof of heavy persuasion.
Heavy persuasion.
Yeah.
Okay.
They look at the complete narrative of how you were hired using the Ferratley factors.
The Ferratley factors.
Yeah. The first big indicator is the origin of contact. If a headhunter tracked you down while you were perfectly happy and not even looking for work, that leans heavily toward inducement.
Right, because you weren't out there handing out resumes.
Exactly. They also scrutinize the degree of persuasion, like, were there unsolicited meetings, escalating financial offers to break down your hesitation?
Really aggressive tactics.
Right. They want to see if the company made specific assurances of longevity, promising you long-term security or an executive track just to get you to sign the dotted line.
So it's really about painting a picture for the judge of just how hard they had to drag you over the finish line.
Yes. The courts also look at the reasonable expectations of both parties. Did everyone view this as a long-term strategic partnership?
Makes sense.
Now, perhaps the most fascinating element courts look at is employee due diligence.
Oh, like doing your homework on the company?
Exactly. They evaluate whether you blindly trusted the recruiter's pitch or if you did your own heavy independent research into the company's financial health and the realities of the project.
Well, I would assume that doing my own heavy research and being a smart, cautious professional would strengthen my case in court.
Ironically, doing your own heavy independent research actually weakens your inducement claim.
Wait, really?
Really?
That is wild. So the more you just take their word for it and blindly leap, the stronger your legal case is that you were induced.
I know it sounds counterintuitive, but the legal logic is actually quite sound.
Walk me through that.
To prove inducement, you must prove that you relied entirely on the employer's persuasion.
I see.
If you conducted your own deep market analysis and consulted outside experts, the company can argue that you made a calculated business decision based on your own research, not solely on their promises.
Because you were relying on yourself, not them.
Exactly. Blind trust is the essence of reliance.
Wow. Okay.
And the final factor courts consider is the length of your tenure at the new job.
Right, because eventually the old job doesn't matter anymore.
Exactly. If you are induced but end up staying at the new company for 15 years before being fired, The inducement multiplier just fades away. Your new tenure overtakes it.
But what if it's a short tenure?
If you get fired after 18 months, that inducement factor remains massively powerful.
So if persuasion alone stretches the notice period, what happens if that persuasion convinces you to physically sell your home and move?
Oh, that changes everything.
Because the financial damage there isn't just a lost job. You have completely uprooted your life. The guide talks about the relocation multiplier.
Yeah, when an inducement requires an employee to move geographically, the financial exposure for the employer just explodes.
I can imagine.
Relocation fundamentally destroys your existing social and professional safety nets. There is a landmark case, often referred to as the Kilpatrick decision, that perfectly illustrates this.
What happened in that one?
A 53-year-old hospital CEO had 29 years of incredibly secure tenure in New Brunswick. He was aggressively wooed to take a new job in Ontario.
Oh, wow, 29 years.
Yeah, he makes the move, uproots his entire life. But notably, he had absolutely no written guarantee of longevity in his new contract. And he is fired after just 6 years.
Man, 6 years is a blip for a CEO who thought he was making the final career move of his life.
It really is. The Ontario Court of Appeal awarded him a staggering 30 months of reasonable notice, which is well beyond the usual 24-month cap.
30 months.
Yeah. While modern jurisprudence has standardized that a bit closer to 24 months, the core ruling remains profound.
Which was?
The court stated that asking someone to pull up their roots and move cities carries an implicit inducement of a secure, permanent arrangement.
What's fascinating here is that even with a short tenure at the new company, if bad faith and relocation combine, it yields a massive payout.
Absolutely.
It really shows how Canadian courts fundamentally refuse to let companies treat a recruited employee's existing career security as something disposable.
The courts recognize the severe human cost of geographical displacement.
So we have established that courts are highly motivated to help induced employees.
Yes, they are.
But what about the contract itself? I mean, these days, corporate contracts are just brutal.
They are very restrictive. Yeah.
They often include an entire agreement clause, which essentially says, nothing discussed prior to signing this document matters.
Right, the classic boilerplate.
And they heavily restrict your termination notice to the absolute statutory minimums. If you sign that document, how on earth do you get around your own signature?
Well, if you are fired shortly after moving, and you try to rely on a standard wrongful dismissal claim based purely on breach of contract, you are in perilous territory.
Because of the contract.
Right. That written contract, with its restrictive clauses and entire agreement provisions, is designed specifically to defeat you.
So the corporate shield actually works. You are just trapped by the fine print.
Not necessarily. The ultimate legal loophole to shatter that corporate shield is bypassing contract law entirely.
Bypassing it? How?
You sue in tort law instead.
Yeah.
Specifically, you use the tort of negligent misrepresentation.
Suing in tort rather than contract.
Yes.
The guide calls out a mic drop precedent for this exact strategy, the Cognos case involving a man named Douglas Queen.
The facts of the Cognos case are the definition of a corporate bait and switch.
Tell me about it.
Douglas Queen was a manager with a highly secure job in Calgary. Cognos interviewed him and enthusiastically assured him they were developing a major new software project.
Okay.
They promised him long-term, stable employment if he came on board to run it. Relying completely on those verbal assurances, he uproots his family and moves across the country to Ottawa.
But I'm guessing the trap was hidden in the paperwork.
You guessed it. The contract he signed contained absolutely no guarantees of long-term employment. In fact, it had a highly restrictive termination clause that allowed Cognos to fire him without cause, giving him just 1 single month of notice.
Oh, man.
Shortly after he starts the new job, the truth comes out.
Let me guess, the massive project wasn't real.
The funding for this major software project had never actually been secured by the executives. When the funding was officially denied by the board, Cognos fired him, adhering strictly to that measly 1-month notice clause he signed.
Cognos probably thought they were legally bulletproof. I mean, they gave him the 1 month of notice that he agreed to and right.
Oh, they were highly confident in their contract. But the Supreme Court of Canada completely dismantled their defense using a strict framework for negligent misrepresentation.
Which allowed Queen to entirely bypass the contract.
Exactly. The framework requires proving several elements. First, a duty of care.
Meaning what?
The court recognizes a special relationship exists during hiring. The employer knows you are relying heavily on their inside information to make life-altering decisions.
Okay, that's one.
Second, there must be an untrue or misleading statement, In this case, guaranteeing funding for a project that didn't actually have the money.
Right. And the third element is negligence. Does that mean the company had to be malicious? Like, did they have to be evil masterminds actively trying to ruin his life?
The employer does not need malicious intent. It is enough that they were simply careless.
Just careless.
Yeah. Failing to exercise reasonable diligence, like passionately promising a long-term role when the hiring manager knew the budget wasn't actually approved yet, that constitutes negligence in making the statement.
Wow. Okay.
Fourth is reasonable reliance. Uprooting a family across the country justifies relying on a hiring manager's assurances. And finally, resulting damages. You must suffer a quantifiable financial detriment directly resulting from the lie.
Here's where it gets really interesting for me.
Yeah.
It's like buying a house because the seller looked you in the eye and swore the foundation was rock solid.
Right.
If the foundation is actually crumbling, it doesn't matter what the standard is contract says.
Yeah.
They legally misled you into signing that document in the first place. The verbal promise in the Cognos case was about the very existence of the job and the funding, which is a completely distinct issue from the mechanical clause in the contract about how to end the job.
That analogy hits the core legal principle perfectly. Because the oral promises were fundamentally distinct from the contractual termination mechanics, the court completely ignored the 1-month severance limit.
They just threw it out.
Totally threw it out. The tort of negligent misrepresentation operates independently of the contract. This allowed Queen to recover massive reliance damages for the complete financial ruin caused by the false promise.
What did he get?
He won compensation for the loss of his secure income, his moving expenses, his lost real estate equity, and the loss of his pension.
Unbelievable.
He completely shredded that 1-month limit because the court ruled that an employer's duty during recruitment goes far beyond just being honest. They must exercise reasonable care to ensure their representations are highly accurate.
But the financial exposure for the company doesn't even stop at the severance and reliance damages.
No, it does not.
The guide mentions a disability time bomb regarding benefits.
Oh, this is a terrifying hidden risk for companies during these extended notice periods. There is a well-known precedent, the Egan versus Alcatel case.
What happened there?
It involved an employee who was wrongfully dismissed, and the employer cut off her health and disability benefits immediately, which, is a very common corporate practice.
Right, you get fired, your benefits stop.
Exactly. However, during what the court later determined should have been her 22-month common law notice period, the employee became severely disabled.
Oh no. So because they fired her wrongfully and cut her benefits too early, she had absolutely no coverage when she actually got sick.
Exactly. And because the employer breached the contract by cutting those benefits during the required notice period, the court held the employer entirely liable for the massive value of her long-term disability benefits all the way until she turns 65.
Until she turns 65.
Yes. When a company wrongfully dismisses someone, they essentially self-insure that person's health for the duration of the notice period.
That liability can easily run into the high hundreds of thousands or even millions of dollars.
Easily. It is a massive risk.
So that covers the massive financial compensation for the job loss itself and the terrifying risks around benefits. But let's shift gears to corporate behavior.
Sure.
What happens when the company isn't just breaching a contract, but they are actively cruel or deceptive during the termination process itself?
The financial exposure multiplies yet again. Historically, courts used to punish bad faith terminations by simply adding arbitrary months to the severance period.
Okay, just tacking on time.
Yeah, it was informally known as the Wallace Bump. But the Supreme Court of Canada eventually destroyed this practice in a case called Honda versus Keys.
Why did they stop doing it?
They ruled that if an employer breaches their duty of good faith and fair dealing in the manner of dismissal, you can't just blindly add arbitrary months of notice. The court must now award actual, quantified moral damages for the mental distress caused by the employer's conduct.
Okay, so they can't just throw months at the problem. They have to put a specific dollar amount on your suffering.
Exactly.
What does that look like in practice today?
We see it applied very aggressively against major corporations. The guide highlights a modern example, Paul versus Hudson's Bay.
Oh, I've heard of this one.
Yeah, it involved a 53-year-old manager with 28 years of service at a major retailer. He was wrongfully dismissed, but the real issue was how they executed the firing.
What did they do?
They humiliated him by marching him out the door. They attempted to trick him into accepting a lower-tier role specifically to kill his common law severance rights.
That's just shady.
It gets worse. They paid a statutory severance via salary continuation rather than a required lump sum, violating employment standards. And they deliberately delayed issuing his record of employment, which blocks access to employment insurance.
They were just piling on the administrative and emotional distress while the man was losing a 28-year career.
Exactly. And the judge penalized the employer heavily. On top of awarding a 24-month notice period, they added $45,000 in moral damages, specifically to compensate the employee for the deceptive and unduly insensitive conduct.
Wow. The guide also mentions punitive damages.
Yes.
So what does this all mean for the difference between moral and punitive damages? Aren't they basically the same thing?
The legal distinction is actually vital. Moral damages exist purely to compensate the employee for their mental distress. Punitive damages exist entirely to punish the employer.
Ah, okay. Compensation versus punishment.
Right. They are awarded for conduct that is malicious, oppressive, and high-handed. The bedrock case for punitive damages in Canada, called Whiten, actually comes from insurance law.
Insurance law.
Yeah, an insurance company baselessly accused a family of arson to force a cheap settlement after their house burned down.
That's awful.
It is. The Supreme Court upheld a $1 million punitive damage award, stating these damages are for retribution, deterrence, and denunciation when a powerful entity exploits a vulnerable party.
So they want to make a public example out of the company so nobody else tries it.
Exactly.
How does that translate to the employment world?
We see it in cases of extreme workplace abuse, like Boucher versus Walmart.
What happened there?
An assistant manager at a major big box retailer was subjected to months of profane public humiliation by her boss, and the corporation completely refused to intervene to stop it.
Yikes.
The jury awarded massive punitive damages. While an appeals court reduced the final numbers to maintain proportionality, they still levied $100,000 against the corporation and $10,000 personally against the abusive manager.
Okay, we have covered a sprawling and frankly terrifying legal landscape today. Let's bring it all together into a practical playbook for both sides of the table.
If we connect this to the bigger picture, survival for employers requires flawless execution.
Flawless.
To mitigate these catastrophic risks, employers must draft ironclad termination clauses that have absolutely no technical errors regarding statutory minimums.
Not a single error.
Right. They need to deploy explicit non-inducement acknowledgments in their offers, literally making the executive sign a statement that they accept the inherent risk of transitioning and were not lured.
Interesting.
They must enforce those entire agreement clauses to try and neutralize negligent misrepresentation claims. And crucially, they must execute the actual terminations with perfect good faith. No trickery, no delayed paperwork, and immediate payment of statutory minimums.
And for you, the employee, if you find yourself induced to relocate and then burned, the guide outlines a very clear offensive strategy.
It certainly does.
First, build a pre-contractual paper trail. Immediately after an interview, email the recruiter confirming that you are resigning from your secure job, specifically in reliance on their promises of a permanent fit.
Yes. Put it in writing before you sign their contract.
Second, plead the relocation multiplier. Use the fact that you geographically relocated to argue for a massive expansion of your notice period.
That is crucial.
Third, weaponize negligent misrepresentation. Sue in tort, so that even if the employer's restrictive contract is legally sound, you can bypass it entirely and extract your reliance damages.
Right.
And finally, pursue bad faith damages if they tricked or humiliated you on the way out.
It is an incredibly powerful, multi-pronged toolkit designed to level the playing field for the employee.
The ultimate takeaway for me is that modern written contracts are not the invincible corporate shields they appear to be.
They really aren't.
If the foundation of the employment relationship was built on a negligent lie, or if the company acts with cruelty, the courts will systematically dismantle that contract to protect the vulnerable party.
The law is highly adaptable in protecting employees from exploitation. But this raises an important question, something for everyone to really mull over.
Okay, what is it?
If the legal system punishes negligent misrepresentation so severely requiring employers to exercise a duty of care over their pre-employment promises, that is, quote-unquote, over and above a duty, to be honest, how will corporate recruiters in the future ever be able to passionately sell a visionary, high-risk project to top talent?
That is a very fair point.
If every enthusiastic pitch carries the risk of betting the entire company's bottom line on its success, does this extreme legal protection for you, the employee, ultimately kill corporate innovation?
That is a heavy thought to leave on. Thank you for joining us on this deep dive. Remember, the next time your phone rings and a headhunter is promising you the moon and the stars to sell your house and move across the country, well, keep questioning the fine print.